just give me 1 second. I'm parking right now.
So maybe I don't understand something. This is a driving while license suspended?
That is correct, Your Honor.
Mr. Harris, are you driving?
Yes, I am.
All right.
We begin at Wasille County District Court in Ann Arbor, Michigan, where a hearing is about to start. Up next is 44-year-old Corey Harris, who logged in virtually from his car.
Mr. Harris, are you driving?
Actually, I'm pulling into my doctor's office, actually. So just give me 1 second. I'm parking right now.
The hearing seemed routine at first, until Judge Cedric Simpson noticed something unusual.
So maybe I don't understand something. This is a driving while license suspended?
That is correct, Your Honor.
And he was just driving. And he didn't have a license.
It turned out Harris was appearing on charges of driving on a suspended license, while actually driving a car during the hearing.
No, I'm looking at his record. He doesn't have a license. He's suspended and he's just driving.
That is correct, Your Honor.
Both Judge Simpson and Harris, who wasn't supposed to be behind the wheel, were completely confused.
I don't even know why he would do that.
Eventually, the judge revoked Harris's bond and ordered him to turn himself in at the county jail.
So defendant's bond is revoked in this matter. Defendant is to turn himself into the Washington County Jail by 6 p.m. today. Failure to turn himself in will result in a bench warrant with no bond.
The video quickly went viral, turning Harris into an internet meme overnight.
I've been laughed at, I've been ridiculed, I have been disrespected.
After spending 2 nights in prison, Harris returned to court, where Judge Simpson finally clarified the situation.
The person that needed to be blamed is the person that he was staring at in the mirror. He didn't do what he should have done. When they suspended his license, and what people don't understand, when they suspended his license in Saginaw, they don't suspend the license. They suspend the privilege to drive in this state. His license was his driving privileges, better stated, were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it.
It turned out that although Harris's suspension had been revoked, he never paid the clearance fees with the court or the Secretary of State. Even crazier, Harris never actually had a valid driver's license in the first place.
He has never had a Michigan license, ever, and has never had a license in the other 49 states and commonwealths that form up this great union.
On top of that, Harris had an outstanding warrant from 9 years ago, something even his lawyer didn't know about.
A warrant.
No, I did not know.
Yes, he has a warrant for his arrest.
The charges? Driving without a valid license, as you probably guessed.
The shocking thing about it is for a driving while license suspended that he didn't take care of. I'm going to take him into custody on the warrant.
Ultimately, Harris was sent back to prison for the 9-year-old charges. 2 days later, he managed to secure a learner's permit, ending his bizarre trial on a somewhat happy note.
You're charged with stealing a Dolphin jersey?
No, ma'am. It showed on that I ain't took no jersey. I ain't took no jersey.
What happens when a defendant shows up to court wearing the very item he's accused of stealing? That's exactly what happened to Nelson Walker in Miami, Florida. Facing third-degree theft charges for stealing over $300 worth of Miami Dolphins merchandise, Walker walked into bond court wearing the same jersey he allegedly stole.
All right, you're charged with stealing a Dolphin jersey?
At first, Judge Diane Ward was suspicious, but Walker claimed he had an explanation for his outfit.
This ain't the one, Your Honor.
No?
No, ma'am. It showed on that I ain't took no jersey. I ain't took no jersey.
Not convinced, Judge Ward asked the public defender to weigh in.
Public defender?
As to Mr. Walker, respectfully, Your Honor, we're going to be raising probable causes.
The public defender, equally confused by Walker's wardrobe choice, instead raised concerns about irregularities in the arrest report.
As to what?
as to this being a felony, because the allegations are an observation of observing the defendant and co-defendant put on a dolphin hats. The officer says A and then says hats, so there's an issue as to whether it's two hats or one hat, but clearly the allegations are the co-defendant.
Perhaps the judge would have been more lenient if Walker didn't already have 29 prior felonies. In the end, Judge Ward set his bond at $5,000 and banned him from Dolphin Stadium for life. Walker's questionable attire landed him in prison.
Your Honor, excuse me for a second. I need some time.
Now, let's compare that to Kisson Wilkins, who faked a heart attack in a courtroom.
Do you have any witnesses here present today?
No, Your Honor.
Wilkins faced multiple charges, including felony assault, in Dayton, Ohio, after allegedly trying to murder a man. He was representing himself at trial.
I had months to research this matter. This is why I suggested to you that you have counsel.
When Wilkins requested more time to prepare his defense, Judge Mary Catherine Huffman refused.
Do not speak out in court again.
This was because Wilkins had repeatedly tried to disrupt previous court proceedings.
Your Honor, would you please ask the bailiff and the sheriffs to just go get a tree and bring it in here?
We are going to take a break.
Just miss the hanging, let the lynching, because this is a lynching. I mean, this is a modern day lynching.
Please get your focus. Now,
That's what it is.
you are not to speak, sir.
Modern day lynching.
He claimed the court was being unfair and even accused the system of lynching him.
I have repeatedly advised you, sir, that you will lose your right to represent yourself because of your conduct. Do you understand that?
No, Your Honor, I don't.
Yes, you do understand.
Having already delayed the trial for 3 consecutive days, Judge Huffman had finally had enough.
She informed me that she had family in another part of Ohio. She did not provide me with that information now.
Wilkins saved his boldest move for last.
She never provided with you. Excuse me, hold on, sir. Your Honor, excuse me for a second. I need some time.
While questioning a witness, something seemed off with Wilkins.
We're going to take a break, ladies and gentlemen. If you'll please step out.
Suddenly, he collapsed, clutching his heart.
Based on your examination, do you have any concerns?
No concerns at all. He may need some water.
Court medics quickly examined him and realized it was a fake.
The defendant is feigning some medical condition.
Judge Huffman remained unmoved, noting that Wilkins was pretending to have a medical emergency.
The defendant is slouching over to the side and acts like he's sleeping. His breath appears to be quite normal. Doesn't appear to be labored in any way. Is that a fair assessment, sir?
Yes.
It's not labored in any manner.
Yes, Your Honor.
Does he appear to be doing anything to you other than sitting in that chair?
No, Your Honor.
A court deputy then used a clever trick to wake him up.
Oh, a remarkable change.
A strong dose of smelling salts revived Wilkins, and the trial immediately resumed.
Mr. Wilkins, do you have any questions for this witness, sir?
Judge Huffman reminded him that his stunt would not cause a mistrial.
You've been checked out by trained deputies who are medics. You've been checked out by a registered nurse as well as an emergency medical technician, all of whom indicate that there is nothing physically wrong with you, nor any reason why you couldn't continue here, sir.
Despite his efforts, Wilkins was ultimately convicted on all charges and sentenced to 42 years in prison, ending his legal career.
Sir, in 5 minutes I'm going to start again, with or without you.
Finally, we have Spencer Allen Boston at the Wilson County Courthouse in Tennessee. Boston, 20, faced a drug charge after receiving a citation for simple marijuana possession during a traffic stop.
Yeah, call and I can't give you there's somebody.
Hey! We the people deserve better. Take
it to jail. Take it to jail.
3. Representing himself, Boston wanted to plead his case.
He wants to represent representing himself in this case. I told him today was just an arraignment. It's either a guilty, not guilty type day, to which he responded, I just want to plead my case to the court. So he didn't want to talk to me after that, so that's why he was.
He tried to argue about marijuana law, but the judge wouldn't hear it.
Yes, sir. I think it's very unfair, the marijuana law here. I think we the people deserve better because marijuana is a very harmless drug and it's been around for ages, since the 80s and 90s.
As the judge began scheduling a trial date, Boston took matters into his own hands.
I've heard that baloney all my life, so don't go any further on that.
Yes, sir.
I don't know whether it's good or bad. All I know is Tennessee still has it against the law. I swore to uphold the laws, and I have to uphold the laws as a judge. It probably is unfair, but I can't change it. You got to go see the legislature to get that change.
Incredibly, he pulled out a joint and lit it in the courtroom.
Now, if you want to plead guilty, you can today, but if you want a trial, we can give you a trial on the officer's day, which it's Officer Vincent.
Officer Vincent?
You want to fix the trial day?
Yeah, we can do that.
That'd be fun, then you make another speech.
He even held the burning joint up to the gallery, as if making a statement.
Boston's sentence for a simple possessions charge of marijuana. And then Boston reaches into his pocket, pulls out a joint, lights it, and starts smoking right there.
For his stunt, Boston was sent to 10 days in jail for contempt of court and faced an additional possession charge. His live demonstration certainly didn't help his case.
There's somebody.
Hey! We the people deserve better. Listen.
Take him to jail. Take him to jail.